Each year, the Federal Highway Administration, or FHWA, allocates approximately $40 billion in federal funds to state departments of transportation, or DOTs, and local public agencies, or LPAs, to construct and maintain our nation's roadways. As a federal agency, FHWA has the responsibility to ensure that these public funds benefit everyone and do not result in discrimination prohibited by Title VI of the Civil Rights Act of 1964. Even though this law banned discrimination in federally funded programs, by the 1980s the U.S. DOT found that discriminatory practices still existed in transportation contracting. In an effort to remedy this situation, the U.S. DOT relied on the principles of Title VI to create a program to level the playing field for minority and women-owned firms to compete for DOT-funded contracts. That program is now called the Disadvantaged Business Enterprise Program, or the DBE program, and is no longer limited to minorities and women. The DBE program applies to state and local public agencies that receive funds from FHWA, the Federal Transit Administration, and the Federal Aviation Administration. As a condition of using federal aid dollars for your LPA construction projects, it is important that you understand what the DBE program is, how it relates to your contracts, and what your specific role is for the program. As recipients of federal funds, state DOTs must comply with U.S. DOT DBE program regulations and ensure compliance by LPAs that award or administer DOT-assisted contracts. The DBE regulations have 6 parts which comprise a DBE program. Like a puzzle, all pieces fit together. Each piece is very important. There are general requirements in the regulations for establishing a DBE program, the objectives and the required records and reports. Most importantly, the regulations require the state to include DBE assurances in every contract and in each financial agreement with LPAs. LPAs must, in turn, ensure that these assurances are in all prime contracts and subcontracts. DBE assurances hold recipients contractually accountable to comply with the state-approved DBE program. Non-compliance can lead to the loss of federal funds or termination of contracts. The requirements to properly implement the DBE program in each state are prescribed in the administrative requirements. These include designating a DBE liaison officer, establishing prompt payment and return of retainage requirements, and developing a monitoring and enforcement mechanism. The monitoring and enforcement mechanism verifies that the work committed to DBEs is actually performed by DBEs and that their payments are consistent with the approved contracts. State DOTs must ensure that all program participants, such as you, the LPA, comply with the DBE program requirements. LPAs must perform monitoring and enforcement activities on federal aid projects. The regulations require the state DOT to set an annual overall DBE participation goal and to explain how they will meet the goal. This section also explains how DBE participation is counted towards DBE goals. It defines commercially useful function and describes good faith effort procedures when a prime contractor cannot meet a DBE goal in a contract. These are contract administration requirements that LPAs must abide by. Other videos are available describing these requirements. Certification is a key component of the DBE program. A primary objective of the program is to ensure that only firms that fully meet the eligibility standards are permitted to participate as DBEs. This part of the regulations establishes the eligibility criteria to qualify as a DBE, which are: number 1, the firm must be a small business for profit. Number 2, the firm must be at least 51% owned by socially and economically disadvantaged individuals. And 3, the firm must be controlled by socially and economically disadvantaged individuals. If you have reason to believe that a firm does not meet these criteria, notify your state DOT. The regulations require that each state handle their certification procedures for DBE applications through a one-stop shopping process, called the Unified Certification Program, or UCP. Once a DBE firm is certified by a UCP, the certification is recognized by all DOT recipients in the state, including LPAs. The regulations also include procedures for making certification decisions and removing the eligibility of DBE firms. A significant component of the DBE program is compliance and enforcement. Failure to comply with the DBE regulations may result in formal enforcement actions or complaints filed against the state DOT or you, the LPA. Additionally, this part of the program outlines the enforcement actions that may be taken against contractors and DBE firms that make false statements or attempt to defraud the government. Lastly, the regulations require cooperation, mandate confidentiality of information, and prohibit intimidation or retaliation against any individual or firm involved in a DBE complaint. To comply with these requirements, each state must establish a DBE program and develop a DBE plan for FHWA approval. The DBE plan is the state DOT's guide on how it will implement the DBE program. It is an essential document for those with DBE program responsibilities, such as you, the LPA. Understanding your role is critical to your ability to comply with DBE program requirements to ensure that your project remains eligible to receive federal funds. What exactly does conformance to DBE program requirements mean for you as the LPA? First, contact your state DOT to get a copy of the state's DBE program plan. Once you receive a copy, you will know what's in the plan, who the DBE liaison officer is, the administrative requirements, and what the state expects LPAs to do. You will need to understand these things to ensure your federal aid contracts comply with DBE requirements. Second, you will also need to know how your state's Unified Certification Program works, where to locate the directory or database of certified contractors, and how to identify the type of work they are certified to perform. This is an important first step in counting DBE participation on federal aid contracts. Bottom line, as the LPA, you must know and follow your state's DBE program plan, unless otherwise indicated by your state. Adherence to the DBE program requirements ensures that your local federal aid project funding is not jeopardized nor delayed due to complaints, challenges, or other issues.